Hey, this is Brian Foley. I am your friendly neighborhood criminal defense attorney in Conroe, Texas. And we're going to be going over Texas Rule of Evidence 504 today. It's called the Spousal Privilege Rule. And it was renamed uh, since I have actually become a lawyer back in 2010. It used to be called the Husband Wife Privileges. And I think they renamed it because you can have husband, husband, and wife, wife privilege now. So, anyway, it's called the Spousal Privilege Rule. It is probably the most confusing and complicated rule about privileges that we have in the state of Texas. Almost every lawyer knows that these privileges exist, but getting down the exact mechanics is a little bit tricky. It's very hard to find somebody who can rattle these off the top of their heads in a precise way. We're going to make it easy for you here today. There are two privileges regarding spouses, and they differ in who can assert the privilege and what is covered by the privilege. So one spouse can stop the other from disclosing things that they said during the marriage, except for in divorce and family violence cases. So that means one spouse can stop you from saying private things that you're supposed to have only said to that spouse. It's a marital privilege, meaning you should be able to tell your husband or wife basically anything and not worry that they're going to go tell it to somebody else in court. Except if it's a divorce case, you can say whatever the other person said. Or if it's prosecution for family violence, then you can't stop the other spouse from talking. And then there's another marital privilege, and that is when one spouse refuses to testify against the other in a criminal case, unless, again, it's a family violence case. So if you're a mob boss, this is like the mob boss wife rule. She doesn't have to testify against him to all the stuff that the mob does, but she can't fail to testify for things that he did against her, family violence, or if it was a divorce case, she doesn't have to not testify. He can't prevent her from testifying. So let's talk about the first one, things that are said during the marriage. The first spousal privilege says that one spouse can affirmatively prevent the other from disclosing information that was supposed to be confidential and was made during the marriage. So what about the secret that you told your spouse about you not really owning the property where all the mineral rights were found? If it was made during the marriage, and you could intend to keep it just between you and your spouse, you could prevent the other person from disclosing this information, even if you get divorced and the other party wants to screw you in litigation and the current owner of the mineral rights. This was the Wiggins versus Tiller case, 230 Southwest 253, Texas Civil Out from San Antonio in 1921. It was regarding a dispute about vehicle ownership instead of mineral rights, but that's the basic outlook there. The exception to this in civil lawsuits is like divorce between two spouses, and then again, family violence cases where one spouse abuses the other, or a child or another household member. You can force that person to testify. But 95% of the time, the spousal privilege is denied. It will be because of a divorce or a family violence case. There are some other exceptions, though. If the two spouses are conspiring together in order to commit fraud against another person, then the communications are not considered privilege. That's from United States v. Ramirez, Fifth Circuit case in 1998. You can also not assert the confidential communications marital privilege if the legal proceeding is to commit the spouse to a mental hospital or challenge their mental competence. So then let's look at the second one, the privilege not to testify in a criminal case. The privilege not to testify in a criminal case is different from the privilege related to confidential communications in that each spouse gets to make this determination by themselves. One spouse can't force the other not to testify in a criminal matter. So if you're the mob boss wife and you want to testify, you're tired of him, whacking people, then you can certainly do that, but he can't force you. The prosecutor couldn't force you to testify, but if you wanted to, your mob boss husband can't stop you either. Let's see. So, I think that's the gist of it. There is a little bit more complexity in the rule. If you want to take a look at it, subsection B is the privilege not to testify in a criminal case. It doesn't apply when they're charged with family violence. Matters that occurred before the marriage, if the spouse is called to testify, matters that occurred before the marriage, that doesn't count either, right? It has to be actual communications that occurred during the marriage. But that's it. I appreciate you guys watching. Remember, this is always for educational purposes. If there are any mob boss wives out there looking for an attorney, you can give us a call if you need to. But otherwise, Have a great day. Don't forget to like and subscribe, and thanks for watching.